Hey James, how's it going today?
Hello, good morning, good afternoon.
Good morning, good afternoon. What time is it in London right now?
It's 4 o'clock. We've got that sort of weird 4 hour difference for
Yeah.
another week between New York and London.
Okay, cool. Well, welcome. Hello, everyone. I'm here today with James Rosewell, and he is going to chat with us about, a little bit into what he's going to talk about at AdMonsters Ops, taking place this June 3rd and 4th in New York City. So, James, would you like to share with everyone a little bit about yourself, a little bit about Move and the initiative?
Yeah, of course. So I'm an entrepreneur and engineer, and back in January 2020, the UK's Competition and Markets Authority were halfway through a year-long report into digital markets, the most thorough report done into the digital market. And through my B2B data business, a real-time device intelligent business called 51 Degrees, I made a submission to the CMA to address some of the concerns that we had about what Google in particular were looking to do, but also Apple had done or were planning to do. That put me in touch with a lot of people, including Tim Cohen, who's a lawyer. So, as I am to engineering, Tim is even more to the law, an ex-competition appeals tribunal judge, very skilled in this field of competition law. And we went to the CMA after they published their report in July and basically said, well, what happens next? And they said, well, we need someone to complain. And that was how Mo was formed. So we're a not-for-profit that has really been set up to educate regulators. We took the same set of arguments and issues to not only the UK CMA, but also the European Commission, Department of Justice, and other regulators who are interested, particularly the country regulators in Europe. And we'll talk a little bit more about what's happened since then in the coming minutes. And really, we have three spheres of operation. So one where we started was very much about regulators, but we also want to educate the industry and explain some of the issues. Thank you for supporting that today. And then also work with standards bodies, because we feel some of the abuses that the monopolists are able to perpetuate are enabled by the standards bodies, and therefore we'd like to see reform of standards bodies. So we operate in those three areas. And really where we want to get to is stable interoperability, just like the telephone system, the railways, the electricity, all these industries beforehand. It's not exactly revolutionary to say we want stability so that we can then innovate on top of that. So the excitement to do with cookies or whatever it might be isn't something that we have to be concerned about. We can be concerned about innovation. And that's really what we want to bring. And we think that needs not only regulators in elected democracies, but also standards bodies in order to support that.
Okay, amazing. So basically, education at the forefront to get us to a point of innovation. And, I read about a CMA report, and in the report that I read about, there were about 39 regulatory issues that they found that Google will need to address before third party cookies can really go away. And, with that being said, it doesn't really look like we'll see the death of cookies in 2024, or does it from your perspective?
Well, let's just unpack the process a little bit before we come to answer the specific question. So I mentioned movement for an open web started in September 2020. One of the first things we did was ask the Competition and Markets Authority to use their interim measures powers to effectively freeze the status quo. So in the UK, it's different to the US. Europe also different to the US, where the regulator can impose remedies on the market without going to court, whereas the US operates a different system. So we asked for that, and we didn't quite get that. We got the commitments, which Google offered to the CMA, and then the CMA accepted in February 2022. So the report you're referring to is the January 31st report under those commitments that the CMA wrote. And the CMA and Google produce a report every quarter. It's aligned to the calendar quarters. So the next one will be due at the end of April. So between now and the AdMonsters conference on the 3rd and 4th of June, we will have another report from the CMA, which is we obviously await with interest. And those commitments apply globally. So these are not, although it's a UK regulator, it's the UK regulator taking a lead among the G7 effectively. So they apply globally, Alphabet apply them globally. So the CMA are very much in that driving seat. And in their January 31st report, they mentioned at least 39 areas of concern. They would describe it as a step up in terms of their level of concern about Privacy Sandbox. Now, of course, they're a reputable regulator, and they haven't actually been asked to make a decision about cookies yet. What happens is Google need to ask the CMA, or what's called trigger the standstill period. So it's effectively Google going to the CMA and saying, under these commitments, we would like you to make a decision about whether the deprecation of cookies can go ahead, or the deprecation of IP addresses, which is another area covered by the commitments, can go ahead. That triggers a 60-day standstill period. So if Google were, say, to start that at the beginning of June, then we'd have June and July. If they would trigger that at the beginning of July, which is when they would have saying they would start it, so beginning of July would be July and August, and then the CMA might ask for another 60 days, so possibly 120 days. So that would take us very close to the holiday season. If they were then going to go ahead, assuming the CMA said yes, you can go ahead with this, takes us very close to that holiday season. So perhaps Google might sensibly say, well, we'll defer to the end of January, for example, 25. But of course, that's predicated on, firstly, Google asking permission, then CMA saying, yes, we give you permission, and then Google saying, okay, well, we won't actually do it this side of the holiday. So we can't take any of those things for granted. And of course, it's the CMA report in April that's going to give us the best barometer as to where the CMA are at in terms of these 39 fairly significant concerns.
Do you want to maybe share a little bit what some of the concerns were?
Yeah, so you've got the self-preferencing. You've got technologies that might disproportionately help Google, or you've got changes that might help some players in the market but not others. That would be a problem. You've got the fact that some of the APIs just really don't work in practice. So if you take related website sets, there's a blog post, it's on the first page of blog posts on the Movement for an Open Web website. We did an analysis into related website sets that might benefit some players in the market over others. And then, of course, you've got the testing that's going on at the moment. Is that going to be enough for the CMA to actually be able to make a decision? So, we would like to see Google testing the Privacy Sandbox in YouTube, for example. It's the perfect information environment, and it would enable us to determine whether the sorts of technologies and approaches that they're approaching actually benefit the market. Of course, Google haven't done that. So we remain of the view Google should be eating their own dog food before they inflict it on the rest of the market.
Right. And I know with the report, the CMA did ask for additional feedback from the industry. So what did the industry have to say?
Well, the CMA have always been asking for feedback from the industry. So I got involved as a small UK business back, as I said, in February 2020. The CMA are always interested in hearing from organizations. The CMA in particular, and the European Commission, again, very different to the United States, really encourage confidentiality. If you say, there's a problem with competition, very often you have a victim. If the victim were to be identified by the monopolists, then that might be a problem. So they absolutely encourage anonymity. So that's why you generally hear from me and Tim from Movement for an Open Web, because the businesses that support us and share our views want to benefit from that anonymity. But you can also write directly to the CMA, and they really, really want to hear from people, and now's the perfect time. Yeah, it's not theoretical anymore. We're now single-digit months away. Get your views known. What's the impact going to be on your business? What has the impact been already? And it can be just something like, we've dedicated 2 weeks worth of developer time and we still can't work out how to use it. Yeah. Whereas with a simple match key facilitated through shared storage and interoperability like a cookie, we don't have that kind of problem. So just the cost to do business under a privacy sandbox world is greater. And indeed, Google have acknowledged that. They've said businesses have to invest. That's a problem. Raising rivals costs is a problem. So telling the market that you have to invest in this thing that we're pushing on the market is in itself a competition concern. So businesses have been coming forward, talking to the CMA. The way we then understand what the summarized view is in that report that I talked about earlier. So the CMA will generally say words to the effect of, "We've heard that," or some businesses have come forward and expressed a concern about this. So it's nicely summarized, but that anonymity is a really key thing. And I know that can be a bit of a anathema to folks in the US, but it's very much embedded in the way that the competition system works over here.
Yeah, it's definitely interesting. When we got on our call yesterday, just to catch up before our live today, we talked about the DOJ filing an antitrust lawsuit this Thursday, and then the EU open investigations into, Apple, Alphabet, Meta, under the DMA, the Digital Marketers Act. And you let me know that things are moving quickly, and it's like these two things happening simultaneously. I sure it's not a coincidence. So like, what are your thoughts on this?
Well, the CMA hosted an event, I think it was about 18 months ago, and they were really focused on cooperation among regulators. And I kind of, it makes sense if you're going to have um, regulators that are broadly aligned, obviously different jurisdictions, different governments, but are broadly aligned, then why wouldn't they share intelligence? Why wouldn't they cooperate with each other? Um, it happens in other fields. Why not this? So I think we know that's happening. We know there is sharing of information, and yeah, the fact that the DOJ announced on a Thursday, and then the EC the following Monday doesn't feel like a coincidence. And of course, the key thing for us is the involvement of Apple. So Google have been running I'll call it the sort of Donald Trump defense for some time. Other people are doing it, so it's not a problem that we're doing it. In fact, we've got to do it in relation to tracking and, as they call it, tracking cookies, etc. And actually, the narrative should really be changing to one of saying, well, regulators are now getting involved. Regulators have expressed their concerns. Obviously, there's some way to go before remedies start to come forward, but we should now be discussing remedies. And those remedies should be deprecating intelligent tracking prevention on Apple, rather than further interference with interoperability by Google or Apple, for example. And only when that happens and we actually see genuine competition in the market, are we then going to start to see genuine solutions for privacy coming forward?
Okay, awesome. Well, this was great. Is there anything else that you'd like to add on the subject?
Well, I think Google call it Privacy Sandbox. I was just starting to talk about those solutions, but there's nothing to say that Apple and Google solutions are the best solutions. There might be far better solutions, and likely, just like safety in automobiles, for example, different users, different purchasers are going to have different requirements around these sorts of things. So we're very much firmly of the view that if we can get competition sorted first, then that will create an environment where different solutions for privacy will come forward, whether that's pets or other solutions that are yet to be advanced. And when the market's functioning properly, then that's where real innovation can occur. And that needs to be not just in the Google world, obviously disproportionate focus because of Google Privacy Sandbox, but also Apple's world as well. So I think the DMA is quite significant. The announcement yesterday, Monday, and again has the potential to be applied in other jurisdictions as well.
Absolutely. Well, thank you so much, James. I'm looking in the comments to see if we have any questions. Doesn't look like we do. But I do want to just remind everyone that we have AdMonsters Ops coming up, taking place this June 3rd and 4th in New York City. Along with James Rosewell, we have Madeline Want, VP of Data at Fanatics Gaming. She's also one of our keynote speakers. So please make sure you head over to our website and get your tickets. In the comments, I see that you could even save $100 if you've attended this LinkedIn Live. So take advantage of that discount. Thank you again, James, for joining us. And everybody, stay tuned. We have more LinkedIn Lives coming. We have one in April, and we have another one with James in early May.
Yeah, we'll have the CMA's April report by then, and so I'm sure things will have moved on again by then. Very much looking forward to it.
Exciting. All right, James. Well, have a good day, and thank you so much.
Thank you. See you in June.
See you in June.